Good morning, ma'am. Are you Peyton Woodruff?
Yes, ma'am.
And Ms. Woodruff was previously in court, entered a plea of guilty in cause number 24, DCCR 1710 to the state jail felony offense of burglary of a building, and in cause number 25, DCCR 0426 to the second degree felony offense of robbery. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
State has to.
Any additions or corrections to that report?
The only correction I observed, Your Honor, was actually, I think it's a typo where they talk about moral, the MRT program. And they reference it as recognition. I think it's recognition.
Okay.
Misspelled. It's not,
Yeah.
that's, I think that's the problem.
Okay.
Nothing from the state.
And Mr. Coleman has filed a sentencing memorandum as well as a request to state's motion to accumulate any sentences. Is that correct? Mr.
That's correct, Judge. I'm inclined to withdraw that motion to.
Thank you. All right. All right, Mr. Kemmler, you may proceed.
Basically, Your Honor, I would defer to the pre-sentence report. It seems to contain all the information necessary for the court. In my mind, I'm not saying the court is bound to give a probation, but certainly the pre-sentence report certainly would tend, in my reading, to indicate that that would be the appropriate sentence. I think paramount in that analysis is the defendant's recognition of her failures and acceptance of responsibility. It's just clear from her rather articulate.
You can speak up, please.
But it's just clear from her rather articulate expression of that in the pre-sentence report, where she accepts responsibility and seems to have enough insight and self-awareness to realize that she needs to make changes in her life to be successful. She has been successful in the past and lacks criminal history. You see from the report. And again, we would just defer to what appears to be the recommendation, the implied recommendation, I suppose, of the pre-sentence report to put her on probation.
Mr. Coleman?
Your Honor, just state has simply made his position clear in his sentencing memorandum. A series of events, notwithstanding her lack of criminal history, but that criminal episode that she engaged in, whereby she received 4 felony offenses of burglary, robbery, 2 possessions of a controlled substance, I think justifies a minimum just sentence of 2 years on the robbery judge and a 24-month sentence on the state jail burglary and right concurrent.
The only thing I would observe, Your Honor, obviously that's a minimum sentence, and that would kind of be the easy way out. But the problem with that is it gives her felony convictions.
No, I'm not inclined. I mean, while I agree with Mr. Coleman that this was kind of a lot of things that happened very quickly, the lack of criminal history shows, in my opinion, that things were going on with regard to substance abuse and mental health. And I think this is a case that would be, I don't see any reason that there would not be a probation given that opportunity at least. So Ms. Woodruff, in cause number 24, DCCR 1710, I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation. In that case, that's the burglar of a building for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll talk about those in just a minute. In cause number 25, DCCR 0426, also find sufficient evidence to find you guilty, but I'm going to defer all proceedings, place you on probation for 10 years in that case. You're ordered to pay a $500 fine, and you're ordered to follow all of the rules and conditions of probation. You will, when you're on probation, they will do a substance abuse assessment, and then they will recommend whatever treatment. And whatever that treatment is that they recommend, whether it's inpatient, outpatient, if they think you need something, then you will be ordered to do it. Do you understand?
Yes,
Also, you'll get a mental health assessment to see if there's anything that you need there to help you be successful. You will be ordered to follow all of those rules as well. You are to have no contact with the victims of the offenses. That's a Toni Morrison and Logan Kotlerich. Also, what is the relationship with John Toops?
He is my ex-boyfriend.
He's going to remain your ex-boyfriend. So you will have no contact or communication with him either. Do you understand? And so if you do everything that you're supposed to on these probations, this is an excellent opportunity. You're fairly young. You don't have criminal history. Obviously, you were going through, like I said, substance abuse issues and mental health issues, and you went all in pretty quickly. This is your opportunity to not be a convicted felon and to be able to serve any sentence while you're out on probation. The downside to that, though, is if you violate any condition of probation at all, you can be brought back into court. You could be found guilty, so you would be a convicted felon. And in the robbery case, you could go to prison for up to 20 years, and in the burglary, up to 2 years. Do you understand?
Yes.
I'm going to hand you, in each of these cases, the trial court certifications. It shows that these were not agreements, and so you do have some rights to appeal. You can talk to Mr. Kimber about that. Yes, sir.
Yeah, there's a matter of a pending drug case.
Yeah.
She was arrested July 21st, 2024, for somehow our office has obtained a lab report from that case, but not the actual case referral. About 2 weeks ago, I put in a call to the sheriff's department, the narcotics department there at the sheriff's department. And apparently returning phone calls is an outdated concept because I'm not used to the phone call back.
Welcome to my world.
Yeah, I was asked to leave a message for Donna in narcotics, and she has today not returned my phone call. So the Jefferson County, BPD, not Sheriff's Department. So the BPD case number is 2024-14337, and this disposition of these cases is intended to dispose of that case as well.
So if it does come into the office, you're going to not indict. So that's the 2024 one. What about the 2025 case? And the PSI shows two. The PSI shows that July one from 2024, but it also shows a March of 2025.
I'm not aware, that would just, is there a case number?
No, it's just listed.
I don't have any hard time over defining that one as well. I don't have a case number thrown on record.
Okay, if you'll just kind of watch for it, then we'll hopefully catch it. Y'all can catch it.
If the court wants to construe that as an agreement, then we would waive our right to appeal. If that wants, if we have an agreement that they're not going to be.
Well, that's what we would need to change all the paperwork. That's done. I can't imagine that getting a probation, there's going to be an appeal issue anyway. So, all right, good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Yes, ma'am. Mr. LeBlanc, you have Marcus Austin. Okay. Come on. Good morning, sir. Are you Marcus Austin?
Yes, sir.
And in cause number 24, DCCR 1942, Mr. Austin's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We've come here before. I think this is announced already. Hopefully, I'm speaking to the prosecutor.
I can't hear
There
you.
may be another case that's, I don't especially said, but I can ready.
Okay.
Court.
Are you ready, Mr. Nichols? Okay. Obviously, I do have another one that we intend to go forward, but things like that change all the time. So I want to make sure Mr. Austin previously, hold on, rejected an offer in February. It was a 35-year sentence. This is an aggravated assault, family violence with a weapon. 35 years was the offer. Nothing's changed with the partner. All right, and you want to go forward with your trial?
You can't come down or something?
We're not here to negotiate. Mr. LeBlanc, I'm sure, has been negotiating with the district attorney.
And Mr. Bond's got with me several times asking if there was any wiggle room, and I've told him strongly no on every occasion.
Okay, so there's your answer. It's 35 years or go to trial. So do you want to reject that and go to trial and let a jury decide? Or do you want to take the 35? What? All right, I'll hold it while y'all take care of the paperwork. What about Lenny Leday? Sometimes it helps when they hear it out loud from everybody that this is it. Oh, well, I don't know. That sounds very reasonable. Oh. Pick Burger King. You get it your way. Or not. Good morning. Are you Lenny Leday?
Yeah.
And Mr. Leday is charged in cause number 23 DCCR 0783 with the offense of sexual assault. And what is the announcement?
Judge, I need a little more time. I mean, he's made it more for, I think, a little prior, I think the court may know, the prior attorney, I'm speaking with Mr. Radford, he's got some things in his file that I need to look at.
Okay.
And I just found that out, so I need to get with him. I mean, you can set it on, I believe it's an older case, even though I knew one.
It is, and it's gone through some attorneys. And so I'm going to give you 30 days. You need to take all that time, get completely caught up so we can get an announcement, visit with Mr. Radford, Mr. Hoffbauer, and then I want an announcement at the next court date.
And I believe the announcement's gonna be trial. I mean, it's
Sure.
trial. So
I just want to make sure you've looked at everything and that you go over it with Mr. Leday, even though other attorneys have. Y'all go over everything again, talk about consequences, options, and then we will get an announcement. And if it's a trial announcement at the next court date, we'll get it on the quickest trial docket. Okay? You can go back with the bailiff. Okay. Mr. Young? Good morning, sir. On Salvador Gomez? How are you, sir?
How are you?
Good, thank you.
The only other thing I caught in the motion was not pictures and video. It's just not
Good morning, you're Salvador Gomez. And Mr. Gomez has 3 cases, 2 intox manslaughters and a driving while intoxicated set for trial for jury selection next Monday afternoon. And what is the announcement? Is everybody ready?
Yes, sir. State's ready. I know Mr. Jones ready to discuss. We asked for special setting happens. As far as I know, ready to go.
Okay. Anything, it looks like there was a motion in limine filed recently. Any issues that we need to take up today with regard to that? Or do y'all want to handle it Monday before we get
Probably
started?
Monday. Judge, it's pretty standard. It's about showing graphic video or pictures. The only issue is in this case, there's really, everything's going to be graphic. And I will do my best, as you know, I've done in the past, to cut it down. I don't want to inundate the jury or the audience with gore, but it's a double fatality that ended up fiery crash. So I mean, I don't have.
Obviously, some will be necessary, but we can go over at the time any limitations that,
We'll be
during that.
as reasonable as we can.
I think we just, ask that they articulate the probative value.
Sure.
Because I think there are a lot that probably, especially given that I don't know who really contested intoxication, causation. And while he hasn't finally made his decision, we still anticipate pleading guilty to the jury.
Okay, and just going forward with punishment.
And in that regard, Judge, I have an election for punishment and an application for community supervision. Can I file those with the court, or do you prefer that I file those electronically?
It's so much easier if you do it electronically. Otherwise, they have to do it electronically for you. So.
I'll take care of that one.
Perfect. Thank you. And if you need, on the application, the clerks, while you guys are here,
She did it for me.
already did it. Okay, perfect. All right, anything else then?
No, Your Honor, I think everyone is prepared to move forward.
All right, we'll see y'all.
As far as scheduling, Judge, because I know his wife and his kids are frankly all working now. And so I'm assuming if I have him here Thursday morning, does that sound probably when getting it done?
I think that's reasonable. It's always hard to say.
I would rather, it's hard to say, I know for all of you guys, I would rather, and I know if they're working, we don't want them to miss too much work. I would rather them be here possibly a day early, just in case. What I don't like to do, if I can avoid it, is have a jury have to leave at 2:00 some afternoon because we don't have witnesses ready. So maybe Wednesday noonish would be, and they might have to wait, and it might be the next day, but I'd rather that if we can.
And I assume we'll pick the jury Monday, start evidence Tuesday?
Correct. So what we'll do, I have just like this week, I have this docket every Tuesday morning. So we'll pick the jury at 1:00 on Monday, and then on Tuesday, we'll actually start trial at 1:00.
Okay.
So because I can't really skip this docket every week. And so, and then we'll go regular times, pretty much 9 to 5 the rest of the time. Okay?
Thank you, Judge.
Yes, sir. If you need anything else, I'm sure Mr. Nichols can help you out, or call the clerks if you need anything about how we do things here or whatever. Okay, perfect. Thank you. We'll see you on Monday.
Thank you.
And that's what makes this courtroom so compelling. This wasn't just about handing down punishment. It was about giving people one final chance to change before it's too late. The judge made it clear that accountability comes first, but when someone shows genuine potential for rehabilitation, the justice system can still leave the door open. At the same time, the other cases on today's docket remind us that not everyone gets the same opportunity. Some defendants are preparing for trial, others are facing decades behind bars, and every decision made inside this courtroom could change a life forever. What do you think? Did the judge strike the right balance between accountability and second chances, or should the sentences have been tougher? Share your thoughts in the comments below. If you enjoy real courtroom breakdowns, legal analysis, and true crime stories, don't forget to like this video, subscribe, and turn on notifications so you never miss the next case. Thanks for watching, and I'll see you in the next courtroom breakdown.